Settling a trust or estate is a pain in the neck. It's time consuming, it's expensive, it's frustrating. Well, if we can identify why it is those things, maybe we can reverse engineer how to fix it. So why is it a problem? Well, it starts with the successor trustee, who's the eldest daughter or caretaking son or sibling, surviving spouse that's responsible for this project that they're not familiar with. They've never done a settlement before. They don't know what all the 10 tasks are that need to get done that support the 10 projects that eventually go into the settlement. So lack of familiarity is one. The other is they were selected because they're the most competent. But because they're most competent, they already have a full schedule. They got their own kids to deal with, their own clients, their own board meetings, their own spouses, their own dogs. And fitting a 250-hour project into their schedule this year is difficult to do. So that's the successor trustee. They don't know the job. They've never done it before. They're already busy. Exacerbating the problem is the drafting attorney, the person that wrote the trust for mom and dad in 2006. Well, that guy was probably a contemporary of mom or dad and is now retired or dead or priced himself out of the market or specializes only in drafting trusts, not actually settling them. So then the successor trustee has this problem of an orphaned settlement where there isn't anyone that is familiar with the facts that's available to help. And in the few cases where the drafting attorney is willing to help, really, probably 80% of a settlement is the blocking and tackling of project management. It's not strictly legal. Maybe only 20% of a settlement is legal. And so the project and the tasks get put on the paralegal's desk or the administrative staff's desk at an hourly rate to be filled in and done whenever there's time in the schedule. But we know in a trust and estates practice that everything's an emergency, everything's busy. There aren't very many gaps in a schedule, and so projects that should take a half an hour get put off for a half a month. Another one of the problems is that the trust and estates practice, for the most part, charges hourly fees on the settlement because they don't know what kind of knots they're going to get tied up in, so they're unwilling to identify a fixed fee. So the long memos get written and long phone calls get had and long meetings in the attorney's office that you have to get on the 101 to drive to get done. And there's a lot of inefficiency because the fee model for the persons delivering the service is antiquated. So what's the solution? The solution would be a law firm that specializes in trust and estate settlement, that says, yeah, we want the mass market. We're not looking for the real rich folks. Let them go to the Loeb and Loeb and Proskauer and Wilkies of the world, who already are happy to settle a $50 million estate, already have the staffing and the fee structure and the support staff to get it done, but one that likes the little cases. That would be one. Number two, this firm would have intimate familiarity with all of the projects within a settlement and all the tasks within the project and have a workflow or a task list or project management competency to get those things done and to manage the communications with all of the parties that are needed to get it done. The real estate agent, the investment advisor, the life insurance guy, the property manager, the CPA. The solution would be a law firm that charges only fixed fees, that at the beginning of the engagement says, hey, this is what it's going to cost to get this thing done. So that the trustee and the beneficiaries know what's going to be paid to get their big check at the end and not have this wondering, is another invoice going to show up for another memo, another research paper that was done? The solution would be that fixed fee would be split, half of it paid up front and half of it paid at the end, so that the law firm is incentivized to conclude the settlement as fast as possible because they want to collect the bonus check at the end, which is exactly what the successor trustee wants and what the beneficiaries want, and it's what the law firm wants. The solution would be a law firm that does everything remote, that doesn't require you to get on the freeway, to come in and sit in a nice boardroom with a cool espresso to talk about stuff, but does everything online with shared document folders and Zoom calls and transcripts, and kind of uses what we learned in the service business to do after COVID. We can run these businesses remote from anywhere. The solution would be a law firm that isn't geographically constrained to the county that they're in, but can serve anyone in California, because anyone in California is covered by the same California probate code. So this firm would be able to serve clients from Eureka to San Diego. Sorry, not Arizona, not Oregon, not Texas, California, because they need to be a specialist in the state that they do these settlements in. Well, you know what? We built that thing. It's called Anados Law. We happen to be in Santa Barbara. My name's Josh Yeager. I'm one of the partners there on a walk with my buddy Dodger. Hope springs eternal. He's never caught anything in his life. And our URL is trustee-help.com. And we've built that firm for the mass market. If your clients need help settling their trusts or estates, or you need help settling a trust or estate, give us a call. We'd love to talk. Ciao.